Hello, everyone. Welcome back to another episode of the Ramos Law Difference Makers podcast, where it is my wonderful opportunity every single week to meet with cool people doing amazing things who are basically making a difference, which is the name of our show. So today is no exception to that. I have with me today a super cool member of our team. He is the one of our key workers' compensation attorneys here at Ramos Law. He does an amazing job. His name is Tom Crowley. Tom, welcome to the show.
Thank you, Dr. Hoven. Glad to be here.
Hey, listen, as we talk about doing these things, a lot of people ask, what would they see in me as a guest? Will say, what do they see in me? Why would they want me to come on the show? And you and I were talking about this a little bit off air, and it's so important that people know what goes on behind the scenes in certain aspects of any business or any venture and that kind of thing. And I think that so many people want to know about different types of law and different types of scenarios. And here you are, a workers' compensation attorney. A lot of people might think they know what that is, but they might not actually know what that is. So could you describe what workers' comp, if we abbreviate it, what is workers' comp? What does it mean? Who's it for? And how does it work in just kind of a summary statement?
Sure. Well, workers' compensation is a state-by-state administered program that compensates workers when they're injured on the job.
And is that any kind of work, or is it all blue collar? Is there white collar workers compensation? Is there all kinds, or is it kind of sequestered?
Oh, it's all kinds of work. If you have an injury on the job, no matter what your job is, you should be covered by the workers' compensation system of the state that you're in. And like I said, it's a state-by-state agency. In Colorado, it's under the Department of Labor. And there's a division of workers' compensation that covers it, and they have rules that everybody abides by. If there's a dispute, you go to a hearing before the Office of Administrative Courts. It's completely administrative based. It's contrary to the common law, which is why it's all statutory.
So what does that mean? For people who don't understand that little bit of language right there of common law and statutory, if you're putting it into the words of someone who might be watching or listening that is, maybe they got injured at work.
Sure.
How would that translate to them?
Okay, well, common law is what the courts make up. In civil court, when you go to court, appellate court, the Supreme Courts, they can make up the law as, the society changes, as society's morals and everything changes. You see it with the United States Supreme Court, where they create law. Statutory and administrative law, and especially in this case workers' comp, is contrary to that. Okay. In common law, you have ideas of negligence, who's at fault, who may or may not be at fault. If the victim is partially at fault, there can be, percentages of fault attributed. And workers' comp is contrary to that because there's no fault assigned in workers' compensation. If you're hurt at work, no matter whose fault it is, the employer and their insurance company is responsible to provide the benefits for you.
So that means if someone as an employee makes a mistake, and they're doing, let's say they're operating heavy machinery and they put it in reverse instead of in forward, and they roll off the back of a dock or something, that was their fault, but they're still entitled to the same deal as if the thing put itself in reverse instead of forward and rolled off the back, and it was then the company's fault. There is no distinguishing fault in workers' comp.
Yep, that's exactly correct. There is no negligence assigned. It's called strict liability, which means if you're hurt at work, in the course and scope of your employment, workers' compensation covers you. And so when I say that statutory, it's contrary to the common law. Everything, all the rights, all the benefits, everything, all the rules are laid out in statutes and rules. There isn't anything that the courts or the administrative law judges can make up or create that's
so they don't
not
have to
in the
decide
statute.
anything. It's already structured.
It is.
Got it.
Some of it comes down to statutory interpretation because legislatures don't always write statutes clear, and they can be open to interpretation. But generally, that the judges and the system follows the statute and the rules.
So now, if we rewind the clock, how did you get involved in this process as an attorney in the first place, and why workers' comp?
Well, that goes back 20 years. When I graduated from law school in Northern Illinois.
Did you always know you wanted to be an attorney?
No, actually, I did not.
Oh, okay. Tell me that story.
Well,
what led you to think law school then?
Well, attorney, this is actually my second career, attorney. when I got out of college, I was a criminal justice major, and I had no desire to be a policeman. And so I went into corrections, and I worked for the Wisconsin Department of Corrections for several years before I realized that the inmates were starting to get smarter than me. So I thought, well, I think I'm going to go to law school. And so after several years of that capacity, I took the LSAT and I got accepted and I went to law school.
Very cool. And did you know that you wanted to be a workers' comp attorney, or where did that come from? Did you start out down a different path and then end up serving the needs and being a champion for injured workers?
I didn't really know much about workers' comp at all. I think my original goal was to be a prosecutor, probably, government and public service attorney. But, I like I said, I sent out some resumes and I got a job offer from a firm, a private firm, not a government, in Northern Illinois. And I walked in the door on my first day, and one of the managing attorneys said, "Turn around, you're coming with me." And we went to the workers' comp division up there and sat through a status call, and that's how I learned it, and that's pretty much where I've been.
Wow. And so I don't know if if something comes on top of your mind or not. Has there been a craziest workplace injury that pops in your mind that you have been involved with that would just make people go, wow, or are you kidding me? Anything like that cross your mind?
Well, I mean, there's always, whenever you think you've seen all the injuries that could happen, there's always something weird, that happens. Most states have what's called a personal comfort doctrine, which means if you're on a break and you're using the restroom or you need to run out to your car or something like that, and you're injured, that's a compensable injury. That's in the course of your employment. And so there's any number of injuries where I had a case once where I hope this isn't too out of line, but a female was in the bathroom and was trying to get a feminine product out of the vending machine, and was reaching her arm up into the vending machine and had cut a big gash in her arm, and that was covered under workers' comp.
Wow.
Even though she was trying to, I think, steal it, and she was injured, but that was covered under the personal comfort doctrine, and so it was a compensable case.
So let me ask you this on that note. We talk about physical injuries all the time, right? Low backs and necks. And I actually want to see from you kind of what some of the more common injuries are that we might not think of, right? Like backs and necks, we think of that all the time from labor stuff.
Sure.
But what are some other issues? But before that even, what about mental health, mental injuries? Does that fall under workers' comp if someone has almost an episodic break? Let's say that they've just been under so much stress, work stress. Now, we can't really separate work stress from home stress because our body absorbs it all. But is that part of the workers' comp system if there's mental health issues, or is it all based on physical?
No, there is benefits for mental injuries. Each state is different when it comes to those kind of things. In Colorado, you can get compensation or what's called impairment for a mental claim. Those have to be supported by a mental health practitioner or a licensed psychologist or a psychiatrist, and the benefits are limited for those injuries. You can get mental claims as a result of a physical claim, where you have a physical injury and that results in a percent of mental impairment. You can get mental impairment or mental impairment and compensation for a mental injury by witnessing a traumatic event.
At work, or even if it's not related to work?
Yeah, at work.
Okay.
So because there's the things happen at work.
Yes.
Unfortunately, more common than it used to be. And people are exposed to that in the workplace, and that can create a mental injury and a mental claim under workers' compensation. Interesting.
Do you know, and this may be, because this is all new area of stuff, is there a workers' comp system or potential system if someone, with COVID being all the thing that it was and is, some people wanted to take the vaccine, some people didn't. And so if they got injured, like we do vaccine injuries here, right? Mm-hmm. But I've never thought about tying it into the workers' comp side of things, where if someone if they could trace it back to where they got COVID at work and got really sick, is that compensable from a workers' comp? On the other side, if they took a vaccine and then got messed up from, at least apparently got messed up from that, is there COVID and workers' comp, or is that not a thing?
No, it is a thing. Mm-hmm. The vaccine part of it, if you have a vaccine reaction or an adverse reaction and the vaccine was mandated by your employer, then it certainly falls within workers' comp. And I've had conversations and worked with Dr. Cooper to determine some of those issues. As far as contracting COVID itself, those are a little bit more tenuous workers' comp claims because, it's difficult to prove where you contacted COVID from. Mm-hmm. Okay, and you have to prove it by a preponderance of the evidence, which means 51%. So if you're if you're at work and you get diagnosed with COVID, there's probably a good chance you might have got it from work, but to get
gotten it anywhere.
You could have gotten it anywhere. You could have got it at the grocery store, or at the gas pump, or anything else. And so, it's difficult for a doctor to say with a reasonable degree of medical certainty that you got this from work.
Makes sense. Let's talk about those professions that are on the road. They're driving. So let's say someone's a delivery person of some sort, and they get in an accident. How does that process work? What if they're driving their own car versus a company car? What if they're on their way to a place? Do they need to go to work first and establish a base at work, and then their driving counts? How does that work? I could see people really wondering about that.
Well, that's several issues in that scenario. You bring up several things. There is a doctrine called the traveling employee doctrine, where if you're traveling for work and you're injured, then it's compensable. Like if you're, you need to fly to another city to attend a conference, and while you're at that conference, you're out to dinner and you're driving a rental car, you're still there in that city because of work, chances are that would be compensable workers' comp injury. Mm-hmm. Generally, in Colorado, coming to and going from work and you're injured, that's not compensable. Unless there's certain factors that are taken into consideration, like if your employer is mandating you be at a certain location at a job site at a certain time and you're injured on the way there, now that's a factor that would lead to a finding of compensability.
But if your job starts at 9 a.m. and you're going from home to work, that's a different deal than if it's not a normal everyday destination for work. Is that right? That's correct. I got it.
And if you're going between job sites, for work and you're injured, that would be a traveling employee scenario, and that would come under workers' comp.
Wow, that's in there. Like, it's weird. I'm sure the people that are watching or listening are going, man, there's a lot about this that you hadn't thought of. And I mean, I'm in this every day with you guys, and I don't spend my whole time in workers' comp, but these are genuine questions that I have. Sure. That I'm sure these other folks are asking. Have you seen and have been able to categorize the most common work comp injuries that you see that might not be top of mind? Again, back, neck, headaches. I'm sure that everyone would think of those. Are there other things that people go like, oh, that could be a work comp injury, and I just didn't even attribute it to necessarily work?
Sure. Well, like I said, every state has their own system and it's different. When I practiced in Illinois, there was a lot of repetitive trauma or cumulative trauma injuries, things like carpal tunnel, cubital tunnel in your elbow, things like that, degeneration, like aggravation of a degenerative condition in your back through years of bending and stooping and lifting and things like that. Colorado is different when it comes to cumulative trauma, and they don't really find those compensable very often.
Really?
Yeah, you have to really have good documentation of the work duties, the amount of force, the amount of repetitions, the amount of torque, and the angles of your hands and the angles of your elbows and things in order to establish a compensable cumulative trauma or repetitive trauma claim like carpal tunnel.
Wow. And I was just going to mention carpal tunnel. It's interesting because so many people ergonomically, if their monitor's not set right, if it's typically the monitor be too low, and so employees, in my work as a chiropractor, I did a lot of ergonomic evaluations and worksite evaluations, workstations, and ideally a monitor is going to be that the bottom third of the monitor should be level with your eyes, right? But most people's monitors are on their desk, and so they're now in a flexed position in their neck, and then if they're not sitting right with their knees at 90-90 to their hips and all this and that, we set posturally up for what you're talking about, an overuse or repetitive stress syndrome. In this case, the stress is not moving and being in the wrong position. And carpal tunnel, it's so fascinating because if you're typing and your wrist isn't at the right level, you are utilizing an incorrect movement day after day after week after month after year. But you're saying that you have to measure forces or something. I don't even know how you would measure that in someone who's writing or typing or mousing versus who's taking a screwdriver and doing a screwdriver every time.
Right. And that's why it's difficult in Colorado to prove those type of injuries, and they would be mostly found uncompensable because you can't quantify, the number of keystrokes you do in an hour or necessarily the angle that your wrists are at while you're keyboarding. A lot of firms, defense firms and defense and insurance companies, and I know that's because I worked for the defense bar, for many years before I switched and represented injured workers. They cite studies from the Mayo Clinic, studies from other places that will confirm that repetitive keyboarding is not a contributing factor to the onset of carpal tunnel because there are many comorbidities to those kinds of things. And we don't need to go into those, but there's a lot of other factors that can lead to carpal tunnel rather than just keyboarding. And so those are tough cases, especially in Colorado, Colorado has medical treatment guidelines that workers' comp practitioners need to follow. And those guidelines also include causation analysis. And so for repetitive trauma or cumulative trauma type injuries, those guidelines spell out how you can causally relate an injury like that to their work. And it specifically says you have to have so many repetitions, using so much force, using so much torque. And if those aren't met, then the treating doctors aren't going to find causation.
Wow. And that puts workers at an interesting place, because here's what I would think of as a provider, right? When I was treating patients and I would ask them, so what all do? You're having this carpal tunnel or this, you might be having golfer's elbow or tennis elbow, epicondylitis, you're having whatever you're having. And as we look at what they're doing in their lives, then there's these repetitive things. So then you ask yourself, well, okay, yeah, you're doing some mechanical work on the side at night on your car, but you do whatever, blah, 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 every single day at work. If you didn't do that, would you have gotten injured, if you will? If we call a CTI an injury, would that have happened? But you can't argue that in this case. Like, we can argue that in other types of the law. The lawyers here will argue that often. Like, had it not been for this car crash, the fact that there was degeneration in your spine wouldn't have been woken up and aggravated to the degree that it is now that your person hit our client. But it doesn't sound like that plays in the workers' comp field, at least here in Colorado.
Somewhat it does. And I think the factor is, you can have a degenerative or pre-existing condition that was asymptomatic. Then you have an incident at work, an accident. And the accident causes the need for treatment or causes the injury. It doesn't necessarily cause the condition, but it aggravates it, exacerbates it, accelerates the need for treatment. Then it can be found compensable.
Got it. And so in white-collar scenarios, white-collar work situations, besides these postural issues or besides things like carpal tunnel or other repetitive use things, are there any other injuries that you've seen or experienced as commonplace in that arena? Well,
it's not necessarily common only to white collars, to everybody, but slip and falls at work.
Oh yeah,
that is a workers' comp. Car accidents. When you're driving, if you're an executive and you're driving to the airport and you're in an accident, no matter if it's your fault, that's a workers' comp scenario. So anything that happens at work, whether it's work necessarily, part of your job duties, isn't necessarily a determinant factor. If you're in the course and scope of your employment when you're injured, walking down the steps into a icy parking lot to get in your car and you slip and fall is a compensable workers' comp.
Wow. So injury. In the parking lot, so let's just say most people don't own their building, right? Most companies don't own the building they're in unless they're a big company. If someone walks outside and slips on gravel, snow, or ice of the parking lot, and if that building owner contracts with someone to keep the stuff clean, is it the property liability damage that would take care of that? Is the work comp, is it a combination, or is that person who is supposed to be taking care of it and didn't do it at the highest levels, or is it some combination of responsibility?
Well, if it's a workers' comp, then it's 100% workers' comp problem. Workers' comp pays for your treatment, will pay any disability, will pay your lost wages. But then you bring up a good scenario. If there's a different entity than your employer who is responsible for the injury, in this case, if there's a separate person who owns and maintains the parking lot that you slip and fall in, then you can also have a claim against that entity.
After the work comp is
You can
completed
have them
or
at the same,
simultaneously?
no, you can have them at the same time. And that arises a lot in car accidents. Delivery drivers who are in accidents that are caused by somebody else, they have a workers' comp claim. There's no question because there's no liability questions, no negligence at all in workers' comp. So your employer pays for those benefits. But you can also make a claim against a negligent party that caused the accident.
Got it.
And the caveat is that workers' comp isn't going to pay for injuries that are caused by a third party. So you can recover from the third party that was negligent and caused your injury, but work comp has a lien on anything that they pay for workers' compensation, which will have to be paid back out of any money you recover from the third party.
Oh, wow. Okay. And is that paid back dollar for dollar?
Well, the statute is dollar for dollar, but there are reasons for people to compromise their positions in most things in the law. And what we do typically in those cases is we negotiate the workers' compensation portion and get a settlement or an award, and then we find out what their lien is. And depending on the liability and the damages in the third party claim, we can negotiate the lien down, because usually they're willing to accept a little bit less than dollar for dollar, unless it's clear liability and very high damages and they know they're going to get their money back dollar for dollar. Then they won't compromise too much. But there's negotiations that take place between the workers' comp carriers and our office and the BI carriers or the liability carriers, and they work everything out.
Here's a question that I've often asked myself. Never really had the opportunity to talk to you about this, even though you and I see each other all the time. If a company has let's just call it a preventative injury plan in place where they're doing education, they have posters up about doing this and that and the other thing, does that put them in any different light than a company who does none of those things and someone gets the same injury? So we've already established that, hey, if they get injured at work, it's at work. But is there a degree of responsibility that a workplace is either A, entitled to have by law in order to protect workers, or B, protects them at a higher level that workers that don't see that? Like, for what about this? Here's might be the ultimate example. For those watching, there's a thing called an AED. And basically what it's for is for heart condition, cardiac arrest, right? And so if someone goes down with a heart attack, if that happens at work, well, they could have had 98% blockage artery for the last 10 years, but it happened at work. Uh-oh, what do we do? And then if that workplace does not have an AED, are they more liable for the damage and potential death or long-term issue than if they did have an AED, or if they did teach first aid, or you know what I'm saying?
Sure. I think the threshold issue that you'd have to determine is whether that heart attack was even a compensable workers' compensation injury. Okay. In Colorado, heart attacks generally are not, unless you can prove an unusual exertion led to the heart attack. And there are many cases out there that say, this guy had a 90% occluded artery and he was who would have had a heart attack if he was at home laying on the couch.
Yes.
Didn't have anything to do with what he was doing at work. And so that wouldn't be a compensable case. But, if there was an unusual exertion that you could show and it resulted in a heart attack, it wouldn't make any difference if the employer had a portable defibrillator and helped him and saved his life. Well, the benefits would be different, obviously, because if your person died and it was a compensable injury, death benefits are separate than other kinds of benefits. But there is no degrees of fault or damages. It's all under the statute. It's not by employer. It's not what the employer does as far as safety. I mean, obviously, employers have a motivation to be safe and keep their employees safe and have the protocols and training programs in place to keep people from being injured, because that lowers their workers' compensation costs and premiums in the long run.
Yes.
But it as far as the damages that are available or benefits are available, it doesn't make any difference if you have a safety program or not.
Got it. And what about if a company chooses not to insure their workers? In other words, they don't sign up for the workers' comp program. Are they more liable to any kind of scrutiny or punishment, if you will, compared to a company that is following the rules and has workers' comp insurance in place?
Yeah, you're mandated by the state of Colorado to have workers' compensation insurance. If you meet the threshold, which I'm not sure what it is. If you have more than 1 or 2 employees, you need to have workers' compensation insurance. If you don't, not only are you going to be liable for the damages under the Workers' Comp Act, the benefits, you're going to be subject to penalties because the state attorney general is going to go after you for not carrying workers' compensation insurance. And so there are penalties and there are fines and they can shut you down.
Wow.
Basically, if you don't have workers' comp.
And how would an employee automatically know whether they are covered by workers' comp at their company? Does it show any deduction from their pay stub, or is there anything that they're going to get to know that their employer does indeed have workers' comp insurance? Because I would imagine if they didn't offer workers' comp insurance, you might say, ooh, I don't know if I want to work here. Or you bring it to the employer and go, look, you don't have workers' comp here, and it's dangerous for you and dangerous for me.
Sure. It depends, I guess, on the sophistication of the employer. There are situations, that we've all heard about, sometimes fly-by-night contractors and things who don't carry workers' comp, and then somebody gets hurt and there's no insurance available or things like that. But I think if you're at a company that's established, they probably will have a handbook for new employees that will tell you if you're hurt on the job, you have to let us know right away because we have to let the insurance comp people know and start a claim for you if you're hurt. Nothing, you don't pay for it. The employer pays the premiums 100%. Part of the employer's premiums go into a state fund that compensates people who are injured for employers who don't have insurance. So there's a surcharge in Colorado for the premiums that you pay, that the companies pay for workers' comp. Part of that premium goes into that fund.
Is that the new law that passed that also has to do with disability or something like that just passed this year, or is that a separate thing? I know that they were just starting something. In fact, we're having it at our company, right? We got from our controller the email that says, hey, there's going to be some more money coming out of your checks for XYZ that's designed to cover family leave stuff and disability, temporary stuff. Are those connected or separate?
Those are separate, and I don't think it's a new law or a new scheme, but it's they change it up a little bit every year and how the state administers that and the surcharges and things like that, depending on the amount of claims they pay the year before or historically, they can change the amount of premiums or the percentage of the premiums that are paid into the uninsured employer fund or the uninsured workers injury fund.
And that kind of make sure that there's money there for someone being injured. And is that money separated in a global fund, Tom, or is it by the company? You're setting money aside for your own company in case a person gets injured.
No, it's a state-run fund and a state-run program where, like you mentioned, if you at a workplace and your employer did not have workers' compensation insurance and you're injured, you can apply to that fund for benefits.
I see.
Historically, that fund has been woefully underfunded and hasn't paid full benefits. I don't know if they ever have, but they will typically pay for your medical treatment, and they may pay a percentage of your wage loss that you incur, and that's pretty much it.
In a best case scenario, what is the wage loss that someone can get if they're injured on the job? It's not 100%, right? Like if you're injured, you don't get your full paycheck, you get a percentage of that. And I don't know if that depends state by state, but can you speak to that for just a moment?
My experience is it's generally similar throughout each state. It's 66 2/3% of your average weekly wage, your gross average weekly wage. And so it's not your full wages, it's a percentage of your wages. In most instances, I believe it's not taxable. I think that's the difference. That's the reason why you get 66 2/3% because they're anticipating you're probably going to take home around that anyway after taxes and everything's taken out of it. And there is a cap in Colorado. There's a cap on that weekly benefit of I think it's just over $1,100.
Oh, so if you're a high wage earner,
if you're a very high wage earner and are earning
six figures,
2,000 or more a week, and you're capped at $1,100 a week for wage loss benefits, it's a pretty big hit.
Wow, and there's no way around that.
There is not, no.
And what if someone is injured at work, and let's say they're a young 25-year-old, whatever, I don't know, someone doing a really hard job, but had they not been injured, they could have moved up and moved up and moved up into management. Does any of that lost income from promotions ever get considered in a long-term deal, or are the benefits just as they are, as they sit, and good luck to you if you can't get a better job? You're never going to be a supervisor. Now, instead of going up the ladder, now you're going to maintain level,
Sure.
but you can't do this job, so you're going to have to go work at a restaurant or something.
Yeah, that's a great question, and I deal with that weekly, multiple times a week, in situations where somebody who is a laborer or a journeyman electrician who or a pipe fitter. I'll use an example for a pipe fitter because they work overhead a lot, with pipe wrenches, and they're have a lot of shoulder injuries and rotator cuff problems. And you're a journeyman pipe fitter, so you're making pretty decent money, and then you get hurt and you have permanent restrictions put on by your treating doctors when you're done, so you can never go back to that line of work again. And states differ on how they see that and provide benefits for that. In Colorado, you don't get any benefits for that. You're done.
Wow.
Where I came from in Illinois, they have what's called a wage differential or loss of future earnings. So if you have a job as a union pipe fitter and you're making $40 an hour, then you get hurt, you get fixed, you have permanent restrictions, you can't go back to a $40 an hour job, but you can go to a $10 an hour job, in retail or fast food or something. There's a benefit available in some states that will pay you 2/3 of that difference for the rest of your life.
Wow.
Because you're losing that opportunity to earn that money you were earning or to advance. In Colorado, they don't have that benefit. So
is there a reason why those kind of things would be different? Is because our fund is woefully underfunded? Our treasurer of that is underfunded? Is that why it's that? Or is it a strategy? Or is it a philosophy? Why are those different? Because that seems like common sense to me.
Yeah, it's a state-by-state decision. It doesn't have anything to do with the employer's fund or the uninsured fund or anything like that. It has to do with the benefits that the legislature wants to put in the statute. And because it's statutory, it's subject to lobbying. It's subject to pressures from both sides, labor and management. Management, I think, in Colorado has the upper hand in negotiations with the legislature, and they have so far kept those type of benefits out of the statute. That would lead to higher insurance premiums for workers' compensation coverage. There's no question if you have to pay those kind of benefits. So any increase in benefits is going to be increase in premiums that the insurance companies are going to charge to pay these increased benefits.
Makes sense.
And so, there's always an issue. Well, we don't want to put the bite on businesses because we're trying to attract businesses to the state. We don't want them to leave because their workers' comp premiums are too high. And that happens a lot in states where they have good benefits because the premiums are high, and sometimes that causes businesses to leave and to a different state where the workers' comp costs aren't as high.
That is fascinating. Do unions have any influence on workers' comp scenarios? How long the statutes, how long the payout goes, the amount of claims? Is a union employee different than another, or state? It's run by the state regardless of your corporation, a small company, or a union employee?
Well, that's a good question too. Keep in mind that the state system is, because it's statutory, it's political, and it gets amended through the political process or changed. And so depending on the unions, some states have a lot stronger unions than other states do. And obviously the unions want to protect the workers and get them the best benefits that they can. And so the states that have strong unions and strong bargaining power through the unions at the state level in the state legislature typically have better benefits for workers' compensation than states that don't have strong unions.
That makes sense. I got one more workers' comp question.
Okay.
Is there any fund or is there any resource to pay for education if someone does get locked out of their ability to do a job of one sort for whatever reason? Let's say they got a horrible concussion and they can't be an accountant anymore because their cognitive issues where they can't process that kind of information. And so they still have huge potential to do some good things, but just not in this area. Is there education that's set up, or is, again, the benefit's the benefit?
Well, the benefit is the benefit that's in the law. And some states have what's called vocational rehabilitation, where if you can't go back to your other job, they'll provide training for you, education for you. I know some states have, I know some examples where injured workers have gone back to college and gotten their master's degree in a completely different field and are able to go back into the labor market and be productive. But some states, and Colorado is one of them, they don't have vocational rehabilitation. They don't have a program for you to, at least in the workers' comp statute, through the Department of Labor, there are training things that you can do, but that's not necessarily part of workers' comp. That might be under the unemployment scenario where they try to get you back to work and they'll offer you some training. But in the workers' comp statute itself, there is no provision to retrain you or to get you back to work, provide job services, job placements, nothing like that.
Wow. So depending on the state you live in, this could be a really big help or a small help. It just kind of depends where you come from.
Yep.
So here's my last question as far as about you. No, actually I got two more questions about you. First one is, what do you enjoy most about what you do as a workers' comp attorney? What does it bring to your life? Why do you do this with all the other types of law that you could do and be super successful at like you are at this one? What is it about workers' comp that fuels your soul?
What really I enjoy about this job is, I mentioned earlier, I used to work for the defense and insurance companies and defend these cases, which was very unrewarding. So when I switched over and started representing injured workers, and I can actually hand the injured worker a check that when he can go and pay his bills and pay his rent and feed his family, and to see the look, on their faces when you do that, that's the most rewarding part.
Beautiful. Last question. Has there been one piece of advice that you've ever been given or that you've learned along the way that you find fundamental to who you are as a person, what you're about, what you do, that you would like to share with me to learn from, as well as for our audience, and so that they could glean something from that as well?
I think how I try to live my life, and I don't know if it's necessarily a lesson or not, is to always, you don't know what anybody's going through, right? But try to walk in their shoes for, people say walk a mile in someone else's shoes, but they won't get you because you're a mile away and now you have their shoes. But but try to put yourself in someone else's position. If you can think like that and understand what they're going through, I think it helps you with the ability to see what they need and how you can help them, if you can.
Man, that was good. Tom, I can't believe how fast this time has gone. This has been an amazing, amazing body of information that people can take and use and ask questions about. If someone wanted to reach out to you, they have a question about workers' comp, they or someone they know was injured at work, they just want to learn more, they want to hear your story, et cetera, how would they best go about reaching you?
Sure. Well, they can just call the firm and they can patch them through to me. And that happens, quite a bit. I answer a lot of people's questions, not necessarily to sign them up as clients, because that's really not what my goal isn't to pressure people to sign up or be a salesman, even though I know that's good for the firm with more clients. But if they just have questions, I'm happy to answer questions, and I'm happy to help them out if they do need representation. We can step in and advocate for them, but I'm always happy to answer questions. They can just call the firm and they'll put them through to me.
Absolutely. And for those people who would want that number, our number is 303-733-6353. That's the Ramos Law general number. And you can ask for Mr. Tom Crowley. And I will say, as I end the show with you today, Tom, exactly what you just shared, that you just talked to a lot of people, it's something that made a difference in one of my personal friends' life. So our mutual friend, his name is John, and John's wife was in a situation, and John, we've worked with John in the past, and now John texts me and says, hey, my wife had a situation, yada, yada, yada. And I didn't know what to do. I'm not an attorney. So what do? I have him talk to you. And I remember you dropped what you were doing and you made time to talk to this person. You heard her story. You went through and you advised her for a long time as far as saying, hey, here's some guidelines. Here's some things to think about. Here's some questions you might ask. And you wanted to just help and see where it went. At the end of the day, it turns out that they did need us and that you were able to help take care of her and her family. But the fact that you were just willing to listen because it was someone who needed listening to, man, that left an impression on me that will never leave. And I can't thank you enough for your heart, your soul to service, and just your desire to do things the right way. You so bleed our core values of caring deeply and pursuing excellence in everything you do and putting others first. So Thank you, Tom, for joining me. This was awesome, and I can't tell you enough what a difference you're making.
Well, thanks. I appreciate it. And I'm glad to speak to anybody if they have any questions about it. And I'm glad that you gave me the opportunity to come on with you.
Awesome. So until next time, remember, keep getting out there and making a difference.